Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. To get started with our program, it is my pleasure to introduce our speakers today. So we have Justice Nathan Mihara, who, after serving over 3 decades as a judicial officer, including 27 years on the Court of Appeal and 8 years in the Santa Clara County Superior and Municipal Courts, joined ADR Services, Inc. to resolve disputes as a neutral in 2020. Known for his affable demeanor and thorough knowledge of the law, Justice Mihara is able to put attorneys and clients alike at ease to reach an equitable solution, even in the most contentious of disputes. As a judge of the Santa Clara County Superior Court, Justice Mihara's assignments covered a broad spectrum of disputes, including civil trials and settlement conferences, law in motion, felony trials, family law, juvenile law, and probate matters. In addition, Justice Mihara is a frequent lecturer and panelist for many judicial education programs, bar association seminars, and law schools, including Hastings College of Law, UC Davis King Hall Law School, UC Berkeley Law, Stanford Law School, and the Santa Clara Law School. We also have Claudia Hagadus Long with us today, who is based in Contra Costa County. Claudia Long has built an exceptional practice over the last 30 years, having mediated over 1,300 disputes as a full-time mediator since 1996, and has handled numerous employment matters with the Department of Fair Employment and Housing, as well as matters involving business, construction, real estate, wage and hour, and probate, trusts, and estates. Prior to becoming a full-time mediator, now with ADR Services, Inc., she was also a civil litigator in both large and small law firms and in-house counsel at a large multinational bank. Known for her ability to resolve complex disputes with multifaceted and multidisciplinary legal, organizational, cultural, and personal issues, Ms. Long has become one of the most preeminent alternative dispute resolution neutrals in the Bay Area. Additionally, she's fluent in Spanish and French and can conduct matters entirely in Spanish when necessary. She's also a well-known novelist with 5 novels, including the most recent 9/10 of the Law to her credit. Thank you again for joining us today, Claudia and Justice Mihara. And without any further ado, I will be pulling up the presentation and you can take it away.
Thanks, Katie. Okay, well, welcome everybody. I am delighted that you're all here. I think the only question pending is when will the dogs start barking? So I apologize. It's the nature of Zoom, folks. The objective of the course is to revisit types of negative bias that affect us in the legal profession. And actually, in this particular case, to suggest positive ways to reduce the likelihood that this kind of bias is going to affect your practice of the law. Justice Mihara and I are hoping that we will examine certain types of positive bias that will enhance your professional relationships and, you know, a bias that can bring understanding, healing, and hope. It's a little bit of a different take on a class we all have taken a few times. Justice Mihara, maybe you could give us some goals and objectives here.
Sure, absolutely. No, Claudia defined that very well, and that's okay about the dogs, Claudia. Yeah, that's why I don't have pets. But anyway, yes, in terms of goals, you know, we're going to be defining bias for you. We're going to be discussing types of bias with you. We'll also give you some perspective, both personal experience perspectives and also legal perspectives as well. And as Claudia was saying, hopefully we'll provide some thoughts for you about helpful and hopeful next steps. So, Claudia, we've got our next slide coming up. There we are. And why don't you speak to this?
All right. Well, we all know about bias by now, right? We've taken classes. We're all trying to eliminate it in our practice. We take hours of courses on how to correct discrimination, harassment, basic and entrenched disparities, and yet bias persists. Maybe we are hoping that maybe a different approach, instead of pointing the finger at one another, we're going to turn the lens on ourselves and looking to live as fully integral, active humans. And Justice Mihara and I talked about how we would approach this differently, looking to promote individual integrity. And I think it starts with consciousness raising. There are other programs available that will help with that. But we need to listen and learn to recognize the overt, the covert, the microaggressions that we all use to separate and stratify our interactions. But once we know about these, how do we change ourselves? People rarely change, and we all know this. People rarely change as a result of accusations. Belittling and chastising don't seem to have the desired effect. And we think that it starts with consciousness raising, but we are, in the practice of law, we've come a long way. We're uniquely analytical and thoughtful as part of our daily work. And how do we bring these positive attributes to the center of our quest for more equal, accepting, accommodating, and fair practice? Ultimately, how do we live and work with integrity?
Claudia, you have put together some personal exercises and that you might recommend to our participants, and maybe you could explain what they are, and that would be our next slide.
Thank you. These are actually silent exercises. Do not do them out loud. Do not, don't send us any emails. But throughout this hour, I'm going to ask you to think of three things. If you remember anything from your Philosophy 101 class that you took in college, and for some of us that was 5 decades ago, so not really. You might recognize some of these maybe from Seneca, or if you remember any of that. Perception, action, reaction are the ways to examine ourselves. And so first, think of a way in which you have experienced negative bias in the legal profession personally. And everyone has. And I do really mean everybody has experienced this. Take a moment and focus on that experience. That's the perception part of the exercise. Then think of a way that you have done something personally to reduce the bias that you have felt against any group. Again, this is a personal exercise in what you have done, an action you've taken that was positive in reducing either your own or basically your own bias. And the third is reaction. Think of a situation where you have witnessed another person behave in a biased way towards a person or a group in a legal setting. And think about, what can you do? What could you have done? How would you live with greater integrity? So those are the exercises that we're going to kind of really probably just subliminally follow throughout this presentation. But I'm going to ask you to keep those in mind today and to perhaps do these exercises on your own tomorrow. I think we can go to the next slide. There we go.
Right. So, so what is bias, and toward what or who, and what are the areas of bias that we're going to be addressing? Well, let's just define bias as a tendency to believe that some people or even ideas are better than others, usually resulting in the treatment of people or groups unfairly. It's also an action of supporting or opposing a particular person or a group in an unfair way. And why is that? It's because there would be a tendency to allow your personal feelings and opinions influence your judgment, perhaps rather than objective fact. And again, the areas of bias we're going to be looking at will be racial, ethnic, cultural, religious, political, socioeconomic, gender, sexual orientation. Those are some of the areas that we believe that this course is designed to address. So, Claudia, in terms of the terms discrimination or the term prejudice, is there a difference? Let's go to the next.
Let's take a look at the next slide.
Yeah.
There we go. Thank you. Assuring you that you will be getting valuable legal input as well. Pollock versus trimodal distribution, which is a new case that just came down about 6 months ago, gives us the differences between discrimination and harassment. And in the legal sense, it could be explained that discrimination may be the act, prejudice may be the internal feeling, and one fuels the other. Our precedent, it says there, explains that the primary difference between discrimination and harassment is that discrimination addresses the explicit changes in the terms, conditions, or privileges of employment. In this case, it's an employment case, and I do a lot of those. Changes involving some official action taken by the employer. Harassment claims, on the other hand, focus on situations where the social environment of the workplace becomes intolerable because of the harassment communicating an offensive message. Why is that important? It's important because in eliminating our own, or attempting to eliminate our own negative biases, we need to understand and focus on both the two different kinds of legal effect. And are we in a position that where our actions are controlling the future of somebody? Are we in a position where we are making another person's life intolerable? Justice Mihara, we often talk about bias in negative terms. Is there something to be said about positive terms of bias?
Yes, yeah, that would be our next slide. And this is something I've been thinking about for a long time. And I think it's worth exploring and focusing on. As Claudia was saying, the focus has been negative, and it should be. It should be in a lot of ways, because bias, of course, damaging bias can be very hurtful and very corrosive, not only personally, but also to people, but also to institutions. And so I think we should also look at the flip side of the coin in terms of positive bias. And what do I mean by that? I'm talking about people's having a bias toward what? Helping others, being encouragement. Some people who have a real heart, for getting involved and tapping into marginalized people in our society, and that sort of thing. And how do they do that? Well, they do it through service. They do it through education. They do it through story sharing. As I said, encouragement and support. So Claudia, our course is speaking to elimination of bias. And in this context, can you share your thoughts on cognitive errors that are apparent here?
Sure, let's do the next slide. Oh, there we go. Oh, there we are. Okay, we already got there. You're ahead of me, Katie. Different forms of cognitive errors: adaptive, social constructs, and confirmation bias. I know we know a lot about this already, but if we could just jump to the next slide, we can have the unreadable. I think it's, hey, there you go. Yeah, the unreadable definition of cognitive bias, courtesy of Wikipedia. It's a systemic pattern of deviation from normal rationality and judgment, whereby inferences about other people and situations may be drawn in an illogical fashion. Okay, so we have basically adaptive bias, which is when our life or our life experience has taught us that a certain person, trait, gender, manifestation, whatever it is harmful to us. And so as an adaptive measure, we react negatively to anybody with that characteristic. The if we could go back to the other two, the slide, go back to, there you go. Social constructs are those that are created by our society. And that's one of the things that many of the classes now are addressing. Social constructs that put people into a pigeonhole and then define them that way. And that is another kind of cognitive error. And the third, of course, is confirmation bias. When you act the way I thought you'd act, I believe that you will always act that way. When society behaves in a way that causes others to behave in a fashion that confirms society's biases. We all know that these are, evolutionarily, sometimes they're valuable because we don't have time necessarily to react to each person as an individual. But in the practice of law, and this is what the class is, bias in the legal practice, we do have time. We have time not to react instantly. There's not a safe falling from the sky that's going to clobber us so that we know that we have to react quickly. And so we have the opportunity to examine our biases and to say, that is a confirmation bias. I thought you'd act that way, and so you did. I need to readdress that. As mediators, we're trying to build on successes and take our small successes, not in a self-congratulatory way, but in a what works better way. And one of the things is to be aware and say, this is one of my biases, and I am reacting this way. So they're all out there. We know we have them. We can't really eliminate bias, but we can address it as lawyers, as integral analytical human beings. I think we can go to the next slide, if you will. Cognitive error, we've talked about that. And next one then. There we go. But Justice Mihara, you've talked about the fact that there are different kinds of biases. Would you like to tell us a little bit more about that?
Sure, I'd be glad to. As this slide is indicating, I look at bias in four different categories. First of all, there's overt bias, and by definition, that kind of bias is obvious. By statement, by behavior, by words. The recipient is pretty clear on what's happening, and the kind of bias and prejudice and discrimination that's being directed at him or her. The second kind of bias is in what we call implicit bias. We won't be going over that, at least I won't be talking about it today. We could have an entire course on that. But the literature tells us that this is a kind of bias when someone, rather than being neutral, has a preference for, or perhaps an aversion to, a person or a group of people, or harbors a negative or positive attitude toward a person or people, or associates negative or positive stereotypes to them without being aware of it. And the literature describes this also as unconscious bias, all right? And the third kind of bias is implied bias, and that's what I'll be talking about today in part. And this is the kind of a bias where the recipient perceives a possible harmful bias or discrimination evidenced by words or behavior of another. But on its face, it's ambiguous. The person who's hearing this and is the recipient of this has to kind of figure it out. And it's not all that clear and requires thought, interpretation, worry, of course, and that sort of thing. And that's what I am referring to as implied bias. And of course, there's fashionable bias, and Claudia's going to be discussing that a little bit later. Right, Claudia?
Right. That's right, yeah.
Okay. It's good to know that we're on the same page still.
Right.
So let's
touch a little bit on some personal experiences then?
Yes, certainly. I'd be glad to. Thank you. Let's go to the next slide. Yes, thank you. Overt bias. Let me talk about overt bias. And a lot has happened to me over my 71 years of existence on this friendly planet. And I'll just share just a few with you very quickly. I remember someone telling me when I was in school. Well, I can't be your friend. I said, well, why not? It's because you're Japanese. I said, what? That was my first experience with bias, and it was, to be honest, it was really confusing. And I remember another example. My aunt was telling me, she lives in the San Francisco Bay Area here, and she was telling me that she made a mistake. She made an illegal turn or something, and this guy rolls down his window and shouts at her and says, "Lady, why don't you learn how to drive? And by the way, go back to where you came from." My aunt was born in California, so that was a tough call for her. I remember when I was in college, I was taking a hike around a beautiful lake in the state of Washington, and this little girl comes up to me, and she looks really sweet, and she says to me, "Are you black?" I said, "What? Are you black?" I said, "No, no." I said, "Why do you ask that?" She says, "Well, my mom and dad told me not to talk to people like you." And I said, "Oh, okay. Well, I'm not black," and I kind of went on my way. But that was shocking to me that a little kid like that would have that kind of hostility, and be so. I was glad she was open about it, though. And then finally, I remember my uncle telling me, again, he was from Northern California here. He was telling me that he tried to buy a home, and he wanted to buy in a particular neighborhood, and the realtor was showing him every place else in the area. And he says, "No, I'd really like to live here." And finally, the realtor said to him, "Look, I can't sell you a home in this neighborhood." He says, "Well, there are plenty of homes." He says, "Yeah, I know that, but I can't sell it to you because you're Asian." And so what my uncle ultimately did is that he bought a piece of land and built his own home on it. But that kind of thing, after a while, it not only gets to you, it sticks with you. And it's very, very hurtful and very, very harmful. That's overt bias. Implied bias, let me give you a couple of quick examples. Basically, similar here. I remember my father and mother telling me after the war, my dad served over 22 years total in the United States Army. I had a very distinguished career as a military officer. And but when he was a sergeant, and just after the war ended, he and my mom were in San Francisco, and they went to a restaurant for dinner, and they sat down, and the waiter was just kind of going back and forth and not serving them, and a long time passed, and that's an example of implied bias. They had to sit there and figure out, now what's going on? Is this guy busy? Is there some kind of, are they short-staffed? I mean, these are the kinds of things that, and ultimately, after a long period of time, the waiter, my father hailed the waiter, and he said, "Look, I can't serve you." And he said, "What?" He says, "No, I'm not going to serve you." And again, didn't really say it's because you are Asian or Japanese or whatever. But my father got the message, but he had to figure it out. And that's an example of implied bias. And a final example, very similar, my father and I was a teenager, I was 14, and we were in Central California. Dad took a side road. I don't know why, but we went into this gas station that had a little ice cream shop in it. And so we went, it was a hot day, and there were other people there. We were waiting our turn. And we were there for an interminable amount of time. After a long period of time, my father, and we were being ignored. I didn't notice, but my father said, "Look, Nathan, let's just go." And I said, "Okay." It took me at least an hour to figure out what went on there. Probably because I'm a little dense when it comes to racial discrimination, I guess, at that age. But when it finally dawned on me, I have to tell you, it was like someone took a knife and stabbed me in the heart. Because I had never seen my father so depressed. And I think it was depressing not only for him, but he was depressed because I was exposed to that, and it really hurt him deeply that I had to experience that. So anyway, again, that was an example of implied bias that you had to figure it out. It wasn't obvious, it was ambiguous, and you had to spend some time on that. So Claudia, could you address overt bias in different contexts? Jim Crow laws, Equal Credit Opportunity Act, CCRs. Could you talk about that, please?
Sure. Again, Justice Mihara has given us the personal view, and each one of those is a heartbreak. And looking at it as lawyers, what have we done since then? What have we done since Justice Mihara was a kid, which was a bit ago? And
let's be honest, it was a long time ago, Claudia.
But The Jim Crow laws that we were also familiar with were repealed. Things changed in 1966 when that happened, 64 and 66. In 1974, I need you to know this, okay? In 1974, a woman without a man was more than just a fish without a bicycle. She could not get credit. She could not get a credit card either. A married woman could not get credit in her own name. The Equal Credit Opportunity Act outlawed discrimination in credit based on race and gender. That work? Well, we're still working on it, aren't we? We're still striving decades and decades later to equalize credit opportunity. But the law changed. Somebody took that step and changed that law. Last night I was signing loan documents and I signed an acknowledgement that of the Fair Lending Notice, the Housing and Financial Discrimination Act of 1977. 1977, we're still signing laws. We're still signing papers today because the lending isn't fair yet. But these are the steps that we have taken under the law. CC&Rs, what Justice Mihara's father experienced, or trying to buy a house in a particular neighborhood, my parents experienced as well. They could not buy in a certain neighborhood, they couldn't rent in certain apartment buildings if you were Jewish. So there were, this is all very real. And that's one of the reasons that the CC&Rs that prohibit sales to people of particular races, religions, or really any other discriminatory factor have been outlawed. Does it eliminate it? No. But what it does, it provides you recourse. And that's recourse that our parents didn't have. So again, building on the good, looking at it and saying, okay, we have laws now. Let's keep going. Fashionable bias. That's something, it's a term that I kind of made up there. And no, it's not bias against people who aren't fashionable, although there is, oddly enough, there is attractiveness bias, there is weight bias, there is bias on socioeconomic clothing bias. There's a lot of different kinds of bias, but what I'm talking about is fashionable bias, the anti-racism du jour, if you will, the acceptable bias, the call-out meme. We tend, working against bias is a lot more than posting a Facebook meme on your page. Stop Asian hate. Well, Justice Mihara, before 2 years ago, did you ever hear anybody say, oh, I want to stop Asian hate? No, you never did, right? And this is suddenly the sentiment du jour. But anti-Asian hate has been in California for over 175 years. We had, the railroads, the laundries, the San Francisco fire, the anti-miscegenation laws. Did you know that it was against the law in California to marry, for a white person to marry an Asian person until after World War II? And all of a sudden we've got a meme, and we've got memes posted by people who until last year never gave a thought to Asians except to call them the model minority. So fashionable bias is a bandwagon. And while allyship helps, it doesn't change bias. Anti-Semitism is experiencing, well, not a rebirth. We saw it happen this past week. It's been here forever. It never really goes away. But a new infusion of support where it's least expected. Ageism is riding its wave of popularity. How many memes start with old white men? Let's start with that. Even folks who have battled for centuries to be accepted into all ranks of society. LGBTQ folks face a new wave of popular discrimination. What the columnist Kevin Fisher-Paulson, who is a deputy sheriff and writes about gay discrimination and in San Francisco was denied the right to march in the Pride Parade in uniform because historically police have been anti-gay. No matter that we want the police to reflect the population, if they do, their members will be ostracized for helping bring about that goal. So I want to alert you to the fashionable bias. Don't jump on that bandwagon. Let's look deep into ourselves and find a more integral way to live. So we can go to the next slide. Katie, could you go to the next slide? Okay, so the big question is, what do we do? Just as Mihara, guide us, please. What can we do?
Well, one of the things that Claudia and I talked about was having a broader understanding of the attack, if you will, or how we address bias in our society. And one of the things that we talked about, I was suggesting, well, wouldn't it be good and helpful if those who are participating today could hear about what judges learn about bias? And that's actually our next slide. So I'm going to be talking about personal experience in that context. Okay. So what do they teach judges? Well, having been a judge for 35 years, I can tell you, and that's actually changing in a way, and I'll be describing that as well. But first of all, a personal view. In those 35 years, I have to say from the very beginning, I was exposed to and was able to participate in classes, in courses and seminars, if you will, about elimination and bias in the context of fairness and access, access to our courts and fairness in the judicial system. So I can tell you from very early on, if not, probably no later than the early 90s, and this was confirmed by me to folks who were working at the Center for Judicial Research and Education, there were courses on this topic, and very, very helpful. But let's get to the law. There are two legal components that serve as the basis for elimination of bias education for judges. And they're fairly recent, actually. Government Code Section 68088 and the California Rule of Court 10.469 subdivision E. Well, let's talk about the Government Code Section 68088. This was enacted in 2019, effective January 1, 2020. And subdivision A of this code provides that the Judicial Council may provide by rule of court training in matters of racial, ethnic, gender bias, sexual harassment, and other biases listed elsewhere in the statutes. Subdivision B1 tells us that the Judicial Council may provide training on implicit bias, and it lists a number of areas and topics that could be addressed. For example, the first being exploring how implicit bias, unconscious bias, or even systemic bias affects our institutional policies and practices. Second, what about a discussion of historical reasons and consequences of implicit bias? Third, examples of how bias affects perceptions and judgments of judicial officers and staff that would result in unacceptable disparities in access to justice in our courts. Fourth, and this was interesting to me because I recall taking some kind of a test like this, but it provides for the administration of bias association tests to increase the awareness of our judicial officers of our own, perhaps unconscious biases. Fifth, discussion of strategies on how to reduce this kind of bias. And sixth, inquiring and discussing how to counteract juror bias. And that's something we see on the bench, of course, as you might imagine. For you litigators out there, you're well aware of this. And then so B3 talks about how the council can adopt rule of court effective by January 1st, 2021 to implement all of this. And goodness gracious, they did. And it came in the form of rule of court, rule 10.469E that was amended effective January 1st of last year. And just briefly, this concerns fairness and access education. And E1 talks about how, in order to assist judges in preserving the integrity and the impartiality of our judicial system through the prevention of bias, judges should regularly participate in fairness and access education, which includes the following subjects, things that we've already talked about: race and ethnicity, gender, sexual orientation, and something I hadn't really thought of before, but persons with disabilities. And finally, E2 is mandatory. And this basically says all judges, Court of Appeals, Supreme Court justices, trial judges, and subordinate judicial officers must participate in education on unconscious bias, prevention of harassment, discrimination, retaliation, and inappropriate workplace conduct. And this education must be taken at least once every 3-year cycle in terms of our education cycles that we judges need to address and satisfy. So even before these statutes, the minimum education requirement for judges for continuing education, much like lawyers have to go through MCLEs, judges have to complete 30 hours of continuing education credits, okay? Interestingly, that before January of 2021, there was no requirement, there was no mandate that judges take courses on elimination of bias, much like lawyers have. And it was interesting to me to learn this because when I was a judge, I always took courses on elimination of bias. And thinking back on it, they were electives, but I took them anyway. Now, as did a lot of judges. Now, though there was no explicit requirement that judges take elimination of bias courses, there was something that is called qualified ethics core courses. And these are done in cycles of every 3 years. And these include elimination of bias education, all right? Now, judges aren't required to take this qualified ethics core course, all right? But by default, I would say, and the Center for Judicial Education and Research confirms this, and this was my guess, is that over 99% of judges take this, even though it's not mandatory. And why? Because it's a prerequisite for obtaining insurance, judicial liability insurance, essentially, right? Go ahead, laugh, Claudia. It's all right. You're among friends. Yeah, I'm glad everyone else is muted. It'd be deafening right now. But judges are actually concerned about being sued. Judges are concerned about what? They're concerned about getting we call stinger letters from the Commission on Judicial Performance. That's every judge's nightmare, you know. And so what this insurance does, it provides you legal representation before the commission. So the vast majority of judges take this course. And so that's how we got our education, all right? Now, there are other types of programs, of course, that CJR, Center for Judicial Education Research, offers. And I'm just going to give you a couple of examples, just two, very, very quickly. I remember taking a course on fairness and access when I was a baby judge, so back in the, late 80s. And it was a 4-day seminar on fairness and access. And one of the days we watched a video. It was interesting because it was a video of a classroom of judges being taught by other judges. And suddenly, in this video, an intruder bursts through the door, is armed with a gun, shouts threats at the instructors, and then turns around and runs out the door. That was the clip. And the instructor said to us, "Okay, judges, what did you see?" And so we went around the room. There were 15, 16 of us, and we talked about what we saw. I couldn't believe that we all saw different things. Someone said, "Well, when the guy came in with the gun," and someone said, "No, it wasn't a guy, it was a woman." "It wasn't a woman." "Are you sure?" "Positive it was a woman." You know, seriously. Well, you know, with the black, the black person with the black sweater. No, it wasn't. It was red. Didn't you see it? It was red. And this is how it went. All right. And without going into a lot of detail, what were the takeaways? Well, the object of this, of course, was to help us empathize and kind of identify with witnesses who are testifying, and they're under a lot of stress. Some of them see and hear things differently, as the instruction tells us, to juries. And the other part of it, of course, was to understand what jurors are going through when they're listening to this, right? But the takeaway for me was, oh my goodness, do all of us here have unconscious biases that are affecting our perceptions? That was a killer lesson for me. And that has stuck with me ever since. The final example I want to give you is judges educate each other. As you probably heard in the earlier session, we talk to each other. And I remember I invited my wife to one of my calendars when I was first became a judge, and we had lunch. I said, "So how'd I do?" And she goes, "Oh, you were great. It was wonderful. You seem to know the law, and you moved the calendar along nicely. But," I said, "Well, but what?" She says, "You were angry." I said, "I wasn't angry." She says, "Well, I know that, but you looked angry." "What do you mean I looked angry?" He says, "Well, I know you weren't angry, Nate. I know you weren't angry, but you have your angry look." I said, "What is that look?" He says, "It's the look that you have when you're really focusing on something, where you're really thinking about something. You know, you got those bushy eyebrows, and you look fierce up there on the bench." Claudia understands what I'm talking about. And so I said, "What am I going to do about that?" So I went out to Long's or CVS Pharmacy or something, and I got a little mirror and I put it on the bench. And I decided, well, I'm going to look at myself occasionally and see if I've got that angry face. And sure enough, I saw it, and I was able to sort of change that behavior. And a number of years later, maybe 15 years later, a new judge was talking to me about the same problem, but their problem was that the lawyers would say, "Judge, I know you're angry with me." "I'm not angry." "I know you don't like my argument." I didn't say anything about that. I'm neutral." No. I can tell. You really hate this." She goes, "No, I don't." And so, so the judge was telling me, what am I going to do about that? And so I gave her a mirror. and months later, she says, you know, Nate, that really worked. It was amazing. So anyway, those are my two stories on digital education. So Claudia, how does elimination of bias operate, work its way into damages and civil actions and perhaps settlements for our mediators out there?
Well, thank you, Justice Mihara. I love seeing what's going on behind. Well, that was down one, yeah. In chambers, let's leave it there. And it's one of those things that, again, it's a combination of reading implied bias and confirmation bias, because people act the way we think they're going to act, and then we expect them to act that way because of who they are. In terms of mediation, as I said before, building on what works, knowing ourselves, knowing what we tend towards, and catching ourselves in the act, examining ourselves, and with a practical application of making ourselves better. And the law is helping us do that a little bit. A couple of new laws in 2020, since most of us missed 2020, is still new. One is CCP section 102.5, and that was effective January 1st of 2020. And that prohibited no rehire clauses in settlement agreements where the employee sued the employer for discrimination or harassment and settled the case. At the end of your slide packet, you are going to be getting full copies of this law and of Civil Code Section 3361. The importance of the no rehire change is that in an effort to prevent settlement from becoming a tool of perpetuation of discrimination or harassment, the legislature has determined that we don't want to punish the harassed or discriminated against party by settling. And if in a big city or in a type of work that is readily available, it's less of a problem. But if you are settling a case for discrimination in an area where this large employer is really the only game in town, or if it's the kind of work that is difficult to find, then having a no rehire clause essentially prohibits that person from working. I understand the countervailing arguments. If we have to rehire somebody who sued us, we're just setting ourselves up, as well as if we decide not to rehire them because of, qualifications issues, they're going to assume that it is a prejudicial or discriminatory act. But nevertheless, the balance is in favor in this case of not punishing the person who's been discriminated against for settling the case. Civil Code Section 3361 is even more interesting. It, in personal injury cases especially, it prohibits the estimation, measure, or calculation of past, present, or future damages for lost earnings or impaired earning capacity to being reduced based on race, ethnicity, or gender. And that is exactly what we're talking about, okay? Without Civil Code 3361, an actuarial table will show you that overall men earn more than women. White people earn more than Black people overall. This is a huge generalization, but that's what the actuarial tables will tell you. So based on those tables prior to January 1, 2020, damages could be assessed as if you ran over a little Black child, it would be better and cheaper than running over a little white child. What? Yeah, because the damages themselves would be less based on actuarial tables. And it also perpetuates the disparity. It says that, now and forevermore, this child has a 50-year working life, and over the course of his life, people like him will never earn as much as people like another, or women will always earn less than men. And so it perpetuates the disparity, and the settling party suffers for it. So this change is significant in leveling the playing field in settlement and in damages for personal injury. I think it's a landmark change, and it's gone a little bit unnoticed, but it's a landmark change. Let's see. So looking back at our little exercises here, we talked about perception, and Justice Mihara, you're going to just add a couple of further insights personally on knowing what you're facing. You talked a little bit about people misperceiving you as angry. Also, the same thing if you are nearsighted as I am, that, that constant scowl. Yes, no, I'm not scowling at you. What other examples can you give us of knowing what you're facing?
Sure. I'd be glad to. Let's go to the next slide. Let me talk about these three things: knowing what you're facing when you're experiencing bias in the courtroom, and finally turning your negative bias experience into a positive one, a positive force. And I'll try to be relatively brief here, but the first thing, knowing what you're facing, what do I mean by that? Let me illustrate it with this example. All right. I'm a young attorney working in the Department of Justice in San Francisco, and I drove up that particular day. I'm in the Civic Center garage. I'm in the elevator. I'm coming up the elevator, and this older white man gets into the elevator, very distinguished looking. He's wearing a nice suit and briefcase. I'm thinking, this guy's an experienced lawyer, is my own bias. As I'm looking at him, I'm thinking, wow, because I'm just a young kid. But he had this scowl on his face. He looked really angry, and he was looking at me, and I thought, did I do something wrong? Did I cut him off earlier, in the street? Or I couldn't figure it out. And being the paranoid young kid that I was, I thought, this guy's probably prejudiced. It must be my Asian heritage. That's all I could think of, and I was getting a little paranoid. And he kept staring at me. And as we got off the elevator, I just took a chance. And I said, well, sir, I hope you have a really good day. And still scowling and with this angry look, he looks me right in the eye and he says this to me. He says, I hate cancer. I said, excuse me? I said, I hate cancer. It's awful. It's terrible. My wife was just diagnosed with cancer. I'm so angry. And he turned and walked away. That was a life-changing moment for me. I just have to tell you that. At age, 28 years old, maybe. And I thought to myself, here is the takeaway. Here's the takeaway. I'm talking to myself. I'm saying, Mihara, you're not as sharp as you think you are. You think you're so intuitive. You think you're so discerning, but you don't know everything. You don't know everything. So that was a really great takeaway. And the second part of that, of course, is don't jump to conclusions. If it's even possible, give someone the benefit of the doubt, unless you're proven wrong. But don't take an ambiguous situation like that and jump to an immediate conclusion. This guy's a racist. He clearly wasn't. So that was a great experience for me. In terms of bias in the courtroom, there are many, many stories I could tell, but there's one that particularly stands out. I was in municipal court. I was in a civil department, and I was getting ready for a civil trial. I had lawyers in my chambers, a young woman attorney and an older male attorney. And we were talking about pretrial motions and so forth. Then out of the blue, this male lawyer says to this young woman attorney, sweetie, dear, you're pretty young and not too experienced, obviously, but I'm just here to tell you that trials are a three-ring circus. They really are, and you never know what's going to pop up. You just got to be prepared for it, and you'll learn along the way. Really condescending, arrogant, and just as I was about to say something to him because I was just furious, this young woman, I couldn't believe what she did. She looked him right in the eye and she said, Mr. So-and-so, listen carefully. I'm a member of the California State Bar, a licensed attorney, number one. Number two, I do know what I'm doing. And number three, this courtroom is not a circus and I am not a clown. I just fell out of my chair. I thought, wow, good for you. And then, of course, I chimed in. I said, counselor, I'm not going to have any of that in this courtroom, in my chambers. It's completely unacceptable. I said, I expect attorneys to carry themselves with dignity, to demonstrate courtesy to other counsel, whoever they are. And I said, I never want to hear or see this kind of behavior again. And of course, the attorney was very apologetic, said, I'm so sorry, Your Honor, it won't happen again. I apologize to you and to Ms. So-and-so. So what's the takeaway on that? The takeaway for me on that was, number one, I was so proud of this young lawyer. I couldn't believe it. But I thought to myself, you got to stand up. If your judgment tells you, okay, this is what I need to do, stand up and be counted on. Okay. And be heard, to be heard. Okay. That was the takeaway for me on that. Just call it out. And if it's a judge misbehaving, you got to call that out too. And if you're not comfortable doing it in front of the judge, of course, obviously you can talk to the APJ about it, the administrative presiding judge, or if it's really egregious, of course you want to take it to the commission. But those are the takeaways for me on that experience. And finally, turning negative experiences into something that might have a positive impact. Now, I refer back to my ice cream story. When I was, again, in the Attorney General's office, I was assigned to talk to a young teenager about his behavior and about the impact of his behavior. He was on a highway in a convertible, shouting racial epithets at another car, a very dangerous situation, and was pulled over and so forth. And part of his counseling, I suppose, was to talk to a member of the Attorney General's office about this. And I was assigned to do it. And I said, sure, I'll do it. So I talked to this kid, and we had a nice conversation. And I told him about what happened to me when I was 14. I said, let me just tell you something. Number one, I think you're lucky that the people in the other car didn't have a weapon, or might not be sitting here today. But then the second thing is that, that kind of language, you might not think of anything of it, but it's very damaging. They're just words, but they're very damaging. I can tell you, I told them about the ice cream story, that story sticks with me to this day. I'll never forget it. It really crushed me. And to see my father hurt like that was just unspeakable. So we said our goodbyes, and he thanked me. And 5 minutes later, my supervisor comes in and says, Nate. I said, what? What'd you tell that kid? I said, what do you mean? He goes, well, he's standing at the elevator. He's just weeping. He's weeping. He's uncontrollably. He said, what did you say to him? And make a long story, I simply said, Eric, I just told him a story about ice cream. That's all I did. He goes, okay. And that was the end of that discussion. But what's the takeaway there? Those of you, and I'm sure there are many, many of you out there who had worse experiences than I've had. And I've had many, many others, of course. But I just want you to bear this in mind, that those are like jewels in your treasure chest of experiences in a way. Why? Because you never know when you can pull that out and use it for good. To use it to help somebody understand the pain of what bias can do, and discrimination and prejudice, how hurtful it is, and how long-term it is. That's a very valuable thing you've got in your treasure chest of experiences. And those are my takeaways. Claudia, slide 18.
We
Do you have
are
a comment?
Coming close to our time limit here. I was going to mention very, very briefly that when I was a beginning lawyer, and I used to go to court a lot because of my job, I stood up and put my folder on the little dais there, and the judge said to me, "Speak up, I can't hear you." I said, "It's because I haven't said anything yet." Anyway, I wouldn't advise that, but nevertheless, I was trying to avoid giving him confirmation bias.
Good for you. Good for you.
On the other hand, on a much more serious note, the woman that Justice Mihara referred to in his story, who spoke up for herself, shouldn't have to.
Exactly. So,
we're trying to change things one person at a time. So going back to my three exercises, we've talked about looking into ourselves, we've looked at perception, and we've looked at action, and we've looked at reaction. Again, striving as we must towards integrity and towards living a life that is a valuable contribution, not just to ourselves, but to society. We are looking to build towards equality and living an ethical life. And it starts with listening. It starts with open listening, and it starts with sharing stories. So there are many, many MCLE courses being offered in which people who have been victims of incredible discrimination in our society share their stories. And why do we all have to take these classes? Because this is important. And we need to listen with an open mind and an open heart to other people's stories. And then we have to learn to look at ourselves and determine, what have we done that's good and how can we build on it? We're not patting ourselves on the back. We're saying what worked, what was right, what was ethical about our action. And the third thing is, what can we do differently? How can we help ourselves and one another strive more towards generosity and kindness? And we're looking at you, and we're looking at ourselves. Group efforts are wonderful, but we can accomplish a lot just on our own, just ourselves. When you see something, say something. Yeah, it's hard and it's scary, but that's part of living a life that we can look back on and say, I behaved ethically. I behaved with generosity and kindness. I listened and I cared. being an example of someone who doesn't harbor the biases that we're fighting against, being somebody who wants to care, who wants to understand what the issues are about, and being the kind of person who cares about everybody, for all people from all backgrounds, and who doesn't discriminate. It's not an easy task. It sounds Pollyanna, but it's not. It takes commitment. It takes practice. And I think that ultimately, that's why we take all these classes. Justice Mihara, you have one more story to share with us, and it's something that I think we can all learn from.
I'll be very brief. I'll be very brief. Just as a closer, this guy's walking on the beach, all right, and he looks down the beach and he sees thousands of starfish that are washed up shore, and he's thinking, all these starfish are going to die. And he sees this old man, throwing these starfish one at a time into the ocean. And he calls up the old man. And he says, look, fella, this is a waste of your time. You're not going to save all these starfish. And the old man bends down, picks up the starfish, tosses it into the ocean. He goes, well, just saved another one. And the takeaway on that is, folks, it's hard, as Claudia was saying, but don't give up. Don't give up. Secondly, be vigilant. And if you see opportunities, I guess my final word to you is go save a starfish. Go save a starfish. Thank you.
Thank you. A recent New York Times opinion, this was an editorial, it was not the New York Times opinion, it was not bad, said that these trainings are worthless, they don't last, they don't work. And, change is always too slow for those suffering, but each increment betters all of our lives. When we look back on what we now take for granted, the Equal Credit Opportunity Act and all of the others, and we remember how long this fight has been going on, we've got to say there is a record of success. Keep building on it. Thank you.
Thank you so very much, Claudia Long and Justice Mihara. Thank you for sharing your personal stories and for this very unique take on what is sometimes beating a dead horse in the elimination of bias topic. Well, everybody, we are going to adjourn for the next 10 or so minutes, and we will return at 12:30 with Judge Murphy's presentation on using arbitration and references to resolve disputes. So thank you again, Justice Mihara and Claudia, for this wonderful presentation.
And thank you all for coming. And thank you, Katie, for keeping us on track.
Thank you.
Bye-bye.
Thank you all.